In the quiet, affluent communities of Florida's Panhandle, Santa Rosa County is known more for its beaches and suburban calm than for medical scandal. But it was here, in November 2023, that a story began to unfold, one that would blur the lines between operating room and marriage, between medical malpractice and criminal negligence, and between a husband's duty as a doctor and his role as a spouse. Hillary Brown was, by all accounts, no stranger to the world of cosmetic enhancement. She was a mother to 2 daughters and a son. She was married to Dr. Ben Brown, a board-certified plastic surgeon with a successful practice in Navarre, Florida. Beyond sharing a home and a family, Hillary also worked alongside her husband at his clinic. She was not merely a patient, she was an insider. And that familiarity, as investigators would later come to believe, may have contributed to a dangerous complacency. As one employee would later tell detectives, she's had numerous things done to her eyes, her face, her stomach. So, this isn't our first rodeo as far as taking this done. That's what's scary. That comment, captured in the aftermath of a medical emergency, would come to encapsulate the prosecution's central concern. That routine had bred recklessness. The day everything went wrong was the 21st of November, 2023. Hillary had come to her husband's office for a series of procedures. This was not a simple Botox touch-up. According to later testimony, the plan included abdominal liposuction, a fat transfer, a scar revision on her abdomen, and later, injections into her face. It was an aggressive combination, even by the standards of modern plastic surgery. And from the very beginning, according to statements given to police, there were warning signs that the clinical environment was anything but standard. A staff member who had been on the job for only a few days before the fateful surgery told investigators that there was a lot of negligence in the office that led to Hillary's cardiac arrest. That is an extraordinary allegation from an employee, especially one so new. But what she described was even more striking. She told detectives that prior to the surgery, Hillary had taken a plethora of pills. What those pills were, no one seemed to know. The doctor, her husband, did not appear to have a complete accounting of what his patient, his wife, had ingested before going under. Then there was the matter of the IV bags. In any accredited surgical facility, IV bags containing anesthetics or other medications are prepared by trained professionals, often pharmacists or specialized nurses under strict protocols. But, according to the employee's statement to detectives, Hillary Brown had prepared her own IV bags. She had mixed her own diluted xylocaine, a brand name for lidocaine, a common local anesthetic herself. This is not a trivial deviation. Self-administered or self-prepared anesthetic mixtures bypass every layer of safety designed to prevent overdose, contamination, or incorrect dosing. The surgery began. The abdominal scar revision was completed. The liposuction and fat transfer were performed. And at first, everything appeared to go smoothly. Hillary was up walking afterward. She was, according to staff, perfectly fine. She was even mixing her own fat to be transferred to her face. This level of patient participation is highly unusual. It suggested a casual atmosphere that would be unthinkable in a hospital setting or a properly regulated outpatient surgical center. Then came the facial injections. Dr. Brown began injecting a numbing medication again, primarily lidocaine, into his wife's lips. Then he injected her left eye area. At that point, Hillary complained of blurriness. But because her eye was swollen, it was assumed the blurriness was simply from the swelling. Then Dr. Brown injected her right eye. And shortly after that, everything changed. Hillary began to seize. Seizures are among the most alarming signs of local anesthetic systemic toxicity, a known risk when lidocaine is administered in excessive amounts or absorbed too quickly into the bloodstream. The staff member who spoke to deputies described the scene in stark terms. Hillary seized for several minutes. She would stop, only to seize again. Each seizure lasted 3 to 4 minutes. That is not a brief, transient event. A seizure lasting 4 minutes is a medical emergency that demands immediate intervention, including airway management, oxygenation, and often administration of benzodiazepines to stop the seizure activity. She had, the staff member estimated, a total of 2 major seizures before anyone could begin working on her. But other accounts would suggest there were as many as 4 seizures before emergency medical services arrived. The question of time would become one of the most critical elements of the case. According to subsequent police investigation, Dr. Brown did not call 911 immediately. Instead, he and his staff attempted to manage the crisis themselves. The delay, prosecutors would later allege, was between 10 and 15 minutes before anyone summoned professional emergency responders. When the 911 call finally came, it was not placed by Dr. Brown. It was placed by another woman at the office, whose voice on the recording is tense but composed. She tells the dispatcher, "We have an unstable patient." She explains that the patient was having surgery, multiple procedures. She mentions seizures. When the dispatcher asks what kind of procedure was being performed, the caller says, "Abdominal, lipo, fat transfer, different things. I don't know them off the top of my head right now." That call is notable not just for what it says, but for what it does not say. There is no mention of who the patient is in relation to the doctor. There is no mention of Dr. Brown by name. The caller is focused on relaying clinical facts, seizures, instability, the need for an ambulance. But when deputies arrived on scene, their suspicions were immediately raised. One deputy, speaking to his supervisor, put it bluntly, "I guess the plastic surgeon was working on his wife, and then we were told she went into cardiac arrest, but I'm not sure she actually did." That uncertainty, whether Hillary had truly gone into cardiac arrest before EMS arrived, or whether that was a later development, would become another point of contention. The deputy went on to express what many would feel listening to the facts of the case. "It just is weird that it's the doctor and his wife." But he noted that the doctor was not alone during the procedure. There were nurses present. That, he reasoned, made the situation less immediately suspicious. "If it had just been the doctor and his wife in there, I would think we're going to have to do an investigation," he said. "That's a little too... If she did die, just for justice for her, we at least need to investigate and make sure everything is on the up and up. But if there were witnesses in the room, that changes it a little bit." Those witnesses, however, would tell a story that did not put the deputy's mind entirely at ease. One staff member described Hillary walking around after the abdominal portion of the surgery, perfectly fine, even mixing her own fat injections. Then came the facial injections, the blurriness, the seizures. The employee noted that Hillary's blood pressure and heart rate were present throughout. She was not in cardiac arrest at first, but that the seizures were severe. Not grand mal, but pretty close. Hillary Brown was eventually transported to a hospital, but her condition was dire. She had suffered what appeared to be significant brain injury from the seizures and the period of instability. She never recovered. 7 days later, on the 28th of November, 2023, Hillary Brown was pronounced dead. For investigators, the death of a patient in a medical setting is not automatically a criminal matter. Medical malpractice is typically a civil issue, but certain circumstances elevated death to the level of criminal negligence. When a doctor fails to meet the most basic standards of care, when a delay in calling 911 allows a treatable condition to become fatal, when a patient is allowed to prepare her own IV anesthetic, when no one tracks the dosage of lidocaine being administered, these are not simple errors. These are, in the view of prosecutors, acts of culpable negligence. And so, months later, Dr. Ben Brown was arrested and charged with manslaughter by culpable negligence. He would plead not guilty, but the path to trial would be anything but straightforward. The central medical question, what actually killed Hillary Brown, would become a fierce battleground between the state's medical examiner and a growing chorus of experts who questioned her conclusions. The battle over science, expertise, and the limits of a medical examiner's authority was just beginning. In the months following Hillary Brown's death, the Santa Rosa County Sheriff's Office and the State Attorney's Office for the First Judicial Circuit of Florida conducted a methodical investigation. They interviewed staff members, reviewed medical records, consulted with experts, and waited for the official determination of cause of death from the District 1 Medical Examiner's Office. That determination would prove to be the linchpin of the entire case. On a date that would later become critical in pretrial litigation, Dr. Deanna Oleski, the medical examiner who performed Hillary Brown's post-mortem examination, issued her ruling. The cause of death, complications related to lidocaine toxicity. Lidocaine, as previously noted, is a common local anesthetic used to numb tissue during surgical procedures. In small, controlled doses, it is safe and effective. But when too much is absorbed into the bloodstream, whether through direct injection into a blood vessel, excessive volume, or repeated dosing, it can cause a cascade of life-threatening effects. These include neurological symptoms like seizures, cardiac arrhythmias, and ultimately, cardiac arrest. The medical examiner's finding gave prosecutors the evidentiary foundation they needed. In 2024, Dr. Ben Brown was formally charged with manslaughter by culpable negligence, a second-degree felony in Florida. The arrest warrant was detailed and damning. Detectives wrote that an employee who had worked for Brown for only a few days before Hillary's death described a lot of negligence in the office that directly led to the cardiac arrest. That employee told investigators that Hillary had taken a plethora of pills before the surgery, though no one seemed to know exactly what they were. She said Hillary had prepared her own IV bags containing diluted xylocaine, a profound deviation from any accepted standard of care. But the most explosive allegation in the warrant concerned the moment when the IV bags ran out. According to the employee, Dr. Brown poured 2 containers of anesthetic into a bowl. He did not dilute them. He did not measure them. He simply poured and then began injecting the concentrated solution into his wife's arms and later into her face. It was shortly after these injections that Hillary complained of blurry vision and facial puffiness, classic early signs of lidocaine toxicity. She began convulsing. And yet, the warrant alleged, Brown continued. Then there was the delay in calling 911. Witnesses told investigators that between 10 and 15 minutes elapsed before anyone summoned emergency help. In a medical crisis involving seizures and potential cardiac arrest, that delay is not a minor oversight. It is, in the prosecution's view, direct evidence of culpable negligence, a conscious disregard for the safety of a patient that rises to the level of a crime. Ben Brown was arrested, booked, and later released on bail. He entered a plea of not guilty. His defense team, led by famed criminal defense attorney Mark O'Mara, immediately began preparing for trial. But O'Mara is not the kind of lawyer who simply waits for a jury to be seated. He is aggressive, meticulous, and willing to attack the state's case at its foundation. And in this case, that foundation was the medical examiner's determination that lidocaine toxicity killed Hillary Brown. To understand why the defense saw this as a vulnerability, one must understand the role of a medical examiner. Medical examiners are physicians, typically forensic pathologists, who investigate deaths that are sudden, unexpected, violent, or suspicious. They perform autopsies, order laboratory tests, review medical records, and synthesize information from multiple sources to render an opinion on cause and manner of death. In doing so, they routinely rely on toxicology reports generated by other specialists. A medical examiner is not expected to be a toxicologist, any more than a toxicologist is expected to perform autopsies. The system works through collaboration. But in a criminal trial, An expert witness must meet a higher standard. Under Florida law, which follows the federal Dober standard for expert testimony, a witness may only offer expert opinions if they are qualified by knowledge, skill, experience, training, or education, and if their testimony is based on sufficient facts or data, is the product of reliable principles and methods, and those principles and methods have been reliably applied to the facts of the case. This is known as a Daubert hearing, a pre-trial proceeding where a judge evaluates whether an expert's testimony is admissible. In early 2026, less than 3 months before Ben Brown's scheduled trial, Mark O'Mara filed a motion requesting a Daubert hearing to challenge Dr. Oleski's qualifications to testify about lidocaine toxicity. The motion was direct and unsparing. It noted that during her deposition, Dr. Oleski had specifically testified that she is not a toxicologist. She had no training or expertise in that field. When asked questions about lidocaine levels and their impact on the human body, she repeatedly stated that such questions would be better asked of a toxicologist. O'Mara's motion argued, "It is clear that Dr. Oleski does not have the expertise to opine as to whether the levels of lidocaine in a person's system at the time of the incident were lethal or not. This is a critical finding of fact for the jury to determine, and allowing a non-expert to provide inaccurate and unsupported testimony would be highly prejudicial to Dr. Brown." That argument alone might have been sufficient to trigger a Daubert hearing. But the defense had more, much more. In a striking turn, O'Mara pointed to a recent Florida Department of Health proceeding in which Dr. Brown's medical license had been reviewed for potential disciplinary action. That proceeding, titled Department of Health versus Benjamin Brown, had included extensive testimony about the cause of Hillary Brown's death. The Department of Health had brought in its own expert witnesses. Dr. Brown had brought in his, and the hearing officer had made a finding that directly contradicted Dr. Oleski's conclusion. Specifically, the hearing officer found that Dr. Oleski had performed her post-mortem examination using what she called a rule-out theory. She had considered various potential causes of death and, finding no other definitive explanation, concluded that lidocaine toxicity was the most likely, because it was the highest on the differential. In other words, she had arrived at lidocaine toxicity not because of positive evidence that lidocaine had killed Hillary Brown, but because she could not rule it out and could not find another cause. By contrast, the defense expert in that administrative proceeding, Dr. Christopher Borgert, a well-known toxicologist, had testified credibly that lidocaine was not the cause of Hillary Brown's symptoms or death. Dr. Borgert had reviewed the same medical records, the same hospital toxicology reports, and the same autopsy findings. His conclusion was not equivocal. He stated, as a toxicologist, that the lidocaine levels in Hillary Brown's system were not consistent with a fatal toxicity. The hearing officer agreed with Dr. Borgert. The Department of Health ultimately suspended Dr. Brown's medical license for 1 year, but the basis for that suspension was not lidocaine toxicity. Instead, the department cited Dr. Brown's failure to call 911 promptly, his failure to maintain adequate medical records, and other deficiencies in his conduct. The question of what actually killed Hillary Brown was left unresolved, but the hearing officer explicitly rejected the medical examiner's theory. O'Mara seized on this in his Daubert motion. He wrote that the Department of Health had acknowledged that based on her assessment using a rule-out theory, she concluded that the cause of death was complications related to lidocaine toxicity because it was the highest on the differential. He contrasted that with the hearing officer's finding that Dr. Borgert credibly concluded that lidocaine was not the cause of HB symptoms or death. And then he delivered the knockout argument. This is a critical finding by a hearing officer after extensive testimony that the findings by the medical examiner, Dr. Oleski, were not accurate. If a neutral hearing officer, after hearing live testimony from both sides in an administrative proceeding, had already found that the lidocaine toxicity theory was not credible, how could the same theory form the basis of a criminal prosecution for manslaughter? That was the question O'Mara was implicitly asking the criminal court judge. But O'Mara did not stop there. He also revealed that Dr. Oleski had been made aware of Dr. Borgert's contrary opinion. In October 2025, Dr. Borgert had sent Dr. Oleski a detailed letter addressing her conclusion and explaining why it was not supported by the medical data. The letter cited specific references from the scientific literature, and Dr. Oleski's response, according to the motion, was essentially to dismiss it. She testified that while she was familiar with the letter, she did not make much of it. To a jury, that kind of dismissal of a contrary opinion from a qualified toxicologist, backed by peer-reviewed science, could be fatal to the prosecution's credibility. To a judge considering a Daubert motion, it raised serious questions about whether Dr. Oleski's methodology was reliable at all. An expert who disregards contradictory evidence without a scientifically valid reason is not applying reliable principles and methods. She is, in effect, sticking to a predetermined conclusion. The state, for its part, would argue that Dr. Oleski is a licensed physician and board-certified forensic pathologist with years of experience determining cause of death. She relied on the available evidence, including hospital records and toxicology reports. Her conclusion was reasonable, even if other experts disagree. And the Daubert standard is not meant to exclude all experts who face criticism. It is meant to exclude junk science. Dr. Oleski's opinion, the state would contend, is far from junk. But the timing of the defense motion was strategic. By filing it less than 3 months before trial, O'Mara forced the state into a difficult position. If the judge granted the Daubert hearing and then excluded Dr. Oleski's testimony on cause of death, the state would lose its ability to tell the jury that Hillary Brown died from lidocaine toxicity. And without that, the prosecution would have to prove manslaughter based solely on the circumstances of the procedure and the delay in calling 911 a significantly harder case to make. The judge would have to decide, is a medical examiner who admits she is not a toxicologist qualified to testify that lidocaine toxicity caused a patient's death over the objection of an actual toxicologist? That decision would shape everything that followed. As the August trial date approaches, Dr. Ben Brown sits in a precarious position. He is free on bail, still practicing medicine under the cloud of a suspended license, and facing a felony charge that could send him to prison for up to 15 years if convicted. His legal team, led by Mark O'Mara, has mounted an aggressive pretrial defense that centers on undermining the state's medical examiner. But even if they succeed in excluding Dr. Oleski's testimony about lidocaine toxicity, Dr. Brown is not out of danger. The charge of manslaughter by culpable negligence does not require the state to prove intent to kill. It requires something else entirely. Under Florida Statute Section 782.07, manslaughter is defined as the killing of a human being by the act, procurement, or culpable negligence of another. Culpable negligence is a term of art in Florida criminal law. It is more than simple carelessness or even ordinary negligence. The Florida Supreme Court has defined it as a course of conduct that shows a reckless disregard for human life or an indifference to the consequences of one's actions that is so flagrant as to imply a willful or wanton disregard for the safety of others. In the medical context, proving culpable negligence is notoriously difficult. Juries are often reluctant to second-guess the split-second decisions of physicians, especially in emergency situations. But the prosecution's case against Dr. Brown is built not on a single error, but on a pattern of conduct that, if proven, could meet the legal standard. Consider the evidence the state would present at trial. The employee who had worked for only a few days would testify that there was a lot of negligence in the office. She would describe Hillary preparing her own 4 bags, something no patient should ever do. She would describe Dr. Brown pouring undiluted anesthetic into a bowl and injecting it into his wife's arms and face. She would describe the seizures, the delay in calling 911, and the chaos that followed. Other staff members, though initially described by the responding deputy as mitigating factors because they were witnesses, would likely corroborate key details: the blurry vision, the puffiness, the seizures lasting 3 to 4 minutes each, the absence of an immediate emergency response. Then there is the matter of the pills. An employee told detectives that Hillary had taken a plethora of pills before the surgery. What were they? Painkillers? Anti-anxiety medications? Muscle relaxants? If Dr. Brown did not know what his patient had ingested, that alone could be evidence of culpable negligence. A surgeon has a duty to know the complete medical picture of a patient before administering anesthetics. That duty is even more acute when the patient is undergoing multiple procedures in a single session. The state would also likely call expert witnesses to testify about the standard of care for outpatient plastic surgery. Those experts would explain that lidocaine has a maximum safe dose, typically measured in milligrams per kilogram of body weight. They would explain that combining lidocaine with other medications, especially those that affect the central nervous system, can lower the seizure threshold. They would explain that when a patient begins complaining of blurry vision and facial swelling during injections, the appropriate response is to stop immediately and assess for local anesthetic systemic toxicity. And they would explain that when a patient begins having seizures, the appropriate response is to call 911 without delay while providing airway support and seizure management. The defense, in turn, would argue that Dr. Brown was not indifferent to his wife's safety. He was her husband, the father of her children, a man who had every reason to save her life. They would argue that he believed he could handle the emergency himself, that he was trained to manage complications, and that his delay in calling 911 was not reckless but reflective of a doctor's instinct to treat first. They would point out that there were other medical professionals in the room who also did not immediately call 911, suggesting that the decision was not obviously wrong in the moment. And then there is the central medical dispute. If the judge grants the Daubert hearing and excludes Dr. Oleski's testimony, the state would be left without a definitive cause of death. The prosecution could still argue that Hillary Brown died as a direct result of Dr. Brown's negligent conduct during the procedure, even without specifying lidocaine toxicity as the mechanism. But that is a difficult argument to make. Juries expect a clear answer to the question, what killed her? If the state cannot provide one, jurors may be left with reasonable doubt. If the judge allows Dr. Oleski to testify, but permits the defense to vigorously cross-examine her about her lack of toxicology training and the contrary opinion of Dr. Borgert, the case becomes a battle of experts. And in such battles, juries must weigh credibility. A medical examiner who admits she is not a toxicologist and who dismissed a toxicologist's contradictory letter without making much of it may not fare well under O'Mara's cross-examination. O'Mara has also signaled an intention to seek a change of venue. The defense will likely argue that pre-trial publicity in Santa Rosa County has been so extensive and so negative toward Dr. Brown that an impartial jury cannot be seated. This is a common motion in high-profile local cases. But as criminal defense attorney Tim Jansen noted in his analysis, this case may not warrant a change of venue. Santa Rosa County is not a small town where everyone knows everyone. It is a growing suburban area with a diverse population. Finding 12 jurors who have not formed a fixed opinion about Dr. Brown is plausible. Still, the defense will make the motion, And even if it is denied, the jury selection process voir dire will be critical. Omara will look for jurors who are skeptical of medical authorities, who have had negative experiences with plastic surgeons, or who believe that bad outcomes do not necessarily equal crimes. The prosecution will look for jurors who believe that doctors should be held to a higher standard, that a delay in calling 911 is inexcusable, and that a husband who operates on his wife has a conflict of interest that clouds his judgment. There's another dimension to this case that cannot be ignored. The victim's family. Hillary Brown was a mother. Her children, 2 daughters, and a son lost their mother in a procedure performed by their father. The family is now fractured in ways that no trial can repair. The father of Hillary Brown, whose identity has not been publicly disclosed in the transcript, is said to harbor deep anger toward his son-in-law. According to the legal analyst Tim Jansen, the grandfather doesn't like this godlike complex of the husband and wants a jury to decide his fate. That family dynamic adds emotional weight to the proceedings. The prosecution may choose to humanize Hillary Brown through family testimony, reminding jurors that she was not just a patient, but a mother, a wife, a daughter. The defense will walk a careful line, acknowledging the tragedy while arguing that it was not a crime. They will likely remind jurors that Dr. Brown lost his wife that day too, that he has to live with the knowledge that his hands were the ones performing the procedure, and that no prison sentence can add to that burden. Beyond the courtroom, this case has broader implications for the practice of outpatient cosmetic surgery in Florida. The state has some of the loosest regulations in the country when it comes to office-based surgery. Unlike hospitals, which are subject to extensive oversight, private surgical offices are often governed by little more than the physician's own judgment. The Florida Department of Health has disciplinary authority, but it is reactive. It acts after something goes wrong, not before. The department's decision to suspend Dr. Brown's license for 1 year, while significant, was not a permanent revocation. He will be eligible to apply for reinstatement, but the criminal case, regardless of its outcome, will follow him forever. Even if acquitted, Dr. Brown's name is now associated with the death of his wife during a procedure he performed. Rebuilding a medical practice under those circumstances is nearly impossible. For the broader medical community, the case serves as a cautionary tale about the dangers of operating on family members. Most medical boards discourage or explicitly prohibit physicians from treating immediate family members except in emergencies. The reasons are obvious: emotional involvement, clouds, judgment. The standard of care may slip, and the physician-patient boundary becomes dangerously blurred. Dr. Brown crossed that boundary repeatedly, not just by operating on his wife, but by allowing her to prepare her own IV bags, by not tracking her medication intake, and by delaying the call for outside help. The trial, scheduled for August, will be watched closely by legal analysts, medical professionals, and true crime followers alike. The outcome will depend on the judge's ruling on the Daubert motion, the effectiveness of jury selection, and the ability of each side to tell a coherent, compelling story about what happened on November 21, 2023. If the state can prove that Dr. Brown's conduct amounted to a reckless disregard for human life, he will be convicted. If the defense can convince the jury that this was a tragic accident, a bad outcome from a procedure that Hillary had undergone before, and that her husband did everything he could to save her once the crisis began, he may walk free. One thing is certain: Hillary Brown is dead. Her children are without their mother, and a Florida jury will soon decide whether her husband's actions crossed the line from medical error to manslaughter. The answer will not bring her back, but it will determine whether Dr. Benjamin Brown spends years in prison or returns to the life he once knew, forever changed but free. The case is far from over. The Daubert hearing, the trial, and the inevitable appeals that may follow will continue to unfold through 2026 and beyond. For now, Dr. Brown remains free on bail, his medical license suspended, his fate in the hands of a judge, and, soon, 12 jurors in Santa Rosa County. The fix, as they say, is in, but only the courtroom will reveal how it fixes.